Restrictive Covenant and Protection of Third Person's Rights. Sections 39 and 40. Secure your property rights and avoid legal headaches. This video explains how Sections 39 and 40 of the Transfer of Property Act safeguard your interests in property deals. Discover how restrictive covenants can enhance your property value and protect your peaceful enjoyment. Understand the rules for running benefits and burdens with land, ensuring your rights are protected even after transfer. Watch this video and become a property law pro. Join your Vinay Shukla on this thought-provoking journey through the Transfer of Property Act. You'll leave with valuable insights and practical knowledge to navigate the world of property with confidence. Subscribe now and hit the bell for more legal wisdom from your Vinay Shukla. Section 39 Transfer, where third person is entitled to maintenance, where a third person has a right to receive maintenance or a provision for advancement or marriage from the profits of immovable property, and such property is transferred. The right may be enforced against the transferee if he has notice thereof, or if the transfer is gratuitous, but not against a transferee for consideration and without notice of the right, nor against such property in his hands. Unpacking Section 39 of the Transfer of Property Act, protecting third-party maintenance rights. Section 39 deals with a crucial situation. What happens when immovable property, land or buildings, subject to a maintenance obligation gets transferred to someone else, transferee? This section protects the third party's right to receive maintenance from the income generated by that property. Let's break it down. Key players. Third person, an individual entitled to receive maintenance, financial support from the property's profits, example, a dependent family member, a retired owner. Transferor, the original owner of the property who sells or otherwise transfers it. Transferee, the new owner receiving the property. The rule: the right to maintenance generally follows the property, meaning it binds the transferee in certain situations. With notice, if the transferee knew about the maintenance obligation before acquiring the property, notice, they must fulfill it. Free transfer, if the transfer was gratuitous, a gift or inheritance, the transferee inherits the maintenance obligation regardless of notice. Exceptions, however, there are two scenarios where the maintenance right doesn't bind the transferee. Paid consideration, if the transferee bought the property for a fair price, consideration, and didn't know about the maintenance obligation, they are not bound to fulfill it. No property left, if the property no longer generates any income, the third person loses their right to maintenance, regardless of the transfer circumstances. Implications. This section ensures predictability and fairness in property transactions. Third-party beneficiaries are not left stranded if the property changes hands. While paid transferees in good faith are protected, transparency and due diligence are crucial. Additional points. The section focuses on maintenance, but similar principles apply to provisions for advancement or marriage. Specific legal details and exceptions might exist depending on your jurisdiction. In a nutshell, Section 39 ensures that a third person's right to maintenance from property income doesn't disappear simply because the property changes hands. It balances the interests of all parties involved in property transfers. I hope this explanation clarifies the essence of Section 39. Feel free to ask if you have any further questions. 40. Burden of obligation, imposing restriction on use of land where, for the more beneficial enjoyment of his own immovable property, a third person has, independently of any interest in the immovable property of another or of any easement thereon, a right to restrain the enjoyment in a particular manner of the latter property, or of obligation annexed to ownership but not amounting to interest or easement, where a third person is entitled to the benefit of an obligation arising out of contract and annexed to the ownership of immovable property, but not amounting to an interest therein or easement thereon, Such right or obligation may be enforced against a transferee with notice thereof or a gratuitous transferee of the property affected thereby, but not against a transferee for consideration, and without notice of the right or obligation, nor against such property in his hands. Illustration: A. Ramlal contracts to sell Sultanpur to B. Shyamlal. While the contract is still in force, he sells Sultanpur to C. Sitaram, who has notice of the contract. B. Shyamlal may enforce the contract against C. Sitaram to the same extent as against A. Ramlal. Unraveling Section 40 of the Transfer of Property Act, restricting land use and binding obligations. Section 40 delves into complex legal territory, dealing with two distinct situations. 1. Restriction on land use for more beneficial enjoyment. Imagine this: you own a beautiful villa overlooking a serene lake. To maintain the lake's tranquility, you agree with your neighbor that they won't operate noisy boats or build large structures blocking your view. This agreement doesn't grant you an interest in their property, like an easement, but it restricts their usage for your more beneficial enjoyment. Now, suppose your neighbor sells the property. Section 40 states that this restriction can be enforced against the new owner, transferee, under certain conditions. They have notice. If the new owner knew about the agreement before purchase, they must abide by it. The transfer was free. If the property was inherited or gifted, gratuitous transfer, the restriction binds the new owner even without notice. However, similar to Section 39, exceptions exist. Paid consideration: if the new owner bought the property for a fair price and were unaware of the restriction, they are not bound by it. No restriction to enforce: if the original reason for the restriction, example, the lake no longer exists, disappears, the limitation becomes unenforceable. 2. Obligation annexed to ownership. This part deals with a different scenario, where the ownership of one property carries an obligation related to another, but not in the form of an interest or easement. Think of it like a covenant attached to ownership. For example, imagine a builder promises to maintain a common park for all residents in a housing complex. This is an obligation attached to owning a unit in the complex. Section 40 again dictates who inherits this obligation upon property transfer. Enforceable with notice or free transfer. Similar to the first situation, the obligation binds the new owner if they knew about it beforehand or received the property through inheritance or gift. Not enforceable against paid transferee without notice. Again, a bona fide buyer unaware of the obligation is not bound by it. Key takeaways. Section 40 protects third-party rights attached to land usage and ownership obligations beyond traditional easements or interests. Notice and consideration play crucial roles in determining whether these rights bind new owners. The section balances the interests of property owners and those benefiting from restrictions or obligations. Remember, this is a simplified explanation. Specific legal interpretations and exceptions could apply depending on your jurisdiction. I hope this clarifies the essence of Section 40. Please ask if you have any further questions about specific scenarios or legal nuances. Wow! We've journeyed through the labyrinthine world of the Transfer of Property Act 1882. If you found this legal odyssey enlightening, consider subscribing for more adventures in the realm of law. This channel is where property intricacies become crystal clear, sprinkled with a dash of practical insights. Stay tuned for deeper dives into easements, mortgages, and the fascinating legal tapestry woven around your property rights. So, let's unravel legal mysteries together. Hit that subscribe button and join the Legal Explorer Club.